He hasn't been feeling well.
So may I begin?
Yes. Thank you.
Good afternoon, everyone. My name is Douglas Kellner. I'll be serving as co-chair today in the absence of our colleague, Commissioner Walsh, who is ill today and was not able to attend. Would the other commissioners introduce themselves?
Gregory Peterson.
Andy Spano.
And then would our staff introduce themselves?
Bob Bren.
Kathleen O'Keefe.
Brian Webb.
Anna Savitro.
Joe Burns.
Tom Connolly.
Lisa Sugarman.
Todd Valentine.
Cheryl Kemper.
Bob Warren.
All right, and I guess we don't have any guests from the public today. That's unusual. First item of business is approval of the minutes for January 12th, both the regular minutes and the executive minutes.
So moved.
Those in favor say aye.
Aye.
Opposed? Minutes are approved. We'll turn to the co-executive directors for the unit reports, Todd Valentine and Bob Brem.
It's been a busy time, full month of January, February. A number of items of significance. I know we did complete the lever report. I might take some of the thunder away from Anna. I know she did a lot of work to get that together, but a number of people towards the end all chipped in to make the report a complete document that we could all approve and deliver. So that was done on February 4th, and it's posted to the website, and it was delivered as required by that chapter law of last year to prepare the report. So we thank everybody who helped to make that possible. Another number of items. I tried to do a little personnel. There had not been any new hires personnel-wise in the general agency. I know Risa probably cover a few. I think a few since our last board meeting from the enforcement unit. But we do have one notable, and that our the second position in the IT department, Dan Valvo. Tomorrow will be his last day. He's retiring after a long career. We will, be sad to see him move on, but ever since he told us he was planning to retire, I've noticed he smiles a lot more. And so we're in the process. That's a competitive class position, so we've been doing interviews, and Todd and I and John and Tom have been sitting in on those just to come up with the position, fill that position, because it's pretty important to the overall success of the agency. Also, another item of interest is, last week was the National Association of State Election Directors meeting in Washington. Todd and I both attended. Todd's a officer of that fine organization, so it runs similar to the state association where every year you move up until you're eventually president. I think Todd is now 2 years away from president.
No, I'll be president next year.
Oh, sorry, 1 year.
Wow, congratulations.
So it's amazing what happens while some of these faraway places. But I thought it was a very productive meeting. Certainly with new commissioners at the Federal Election Assistance Commission, we went 3 years with no one. They are certainly very knowledgeable, all three of them. They come from, they certainly have a very good credentials in the field that we are under. And they're really working to jumpstart a number of initiatives. They were confirmed by the Senate on December 16th, and it took a little while for them to get up and running, so they've been pretty much in their position for about a month, but they really are trying to, do what's needed to run the agency and come up to speed. And one of them, a number of fronts, but one of them is the standards board that requires each state to appoint 2 people. So today I'm doing that part of the component. There's a state official that is an appointee and an appointee of the other party. So Tony Scannapicchio yesterday gave me the Republican appointee, which is Rachel, the commissioner from Albany County, and Commissioner Kellner on our side from the state level. As of last Thursday, there were only 8 confirmed members of the panel, and they're out of 110. So as soon as we can all respond to the new request to identify who our state representatives will be, the EAC is looking to schedule that meeting and to update that the VVSG that is used to do the standard, the standards for the testing. And there really have been a lot of technological changes just in the last 3 years, but there are many states who bought equipment a little earlier than New York that are really pushing to get, the standard set and something that they can rely on to make these purchases. So that was, there were a number of very worthwhile panel discussions, I think, and similar issues that a number of states are looking at as to how to address things. I think one of the most appropriate is if you look at just so short a period of time ago, 10 years ago, how we keep getting our mindset around how we communicate with the public and how we expect to communicate back. It wasn't that long ago where it was not a surprise to people that if they moved or did something, that they had to tell everybody. When you're in the, you moved your address, you went to the post office, and you get that packet with the little postcards to tell everybody you've moved. And I don't think society is willing to accept in this day and age that I have to really tell everybody, because everything is so automated now. There's some expectation that we should all be able to make it a little easier and figure it out, and it's interesting to see how a lot of the other states are looking to incorporate that thinking. They haven't succeeded, so it's nice to talk to them about their challenges, but it's we're in that same hunt. But it was very worthwhile adventure. But other than that, I think it's the routine work to get the packet ready for today. The budget did come out, which was similar to what was submitted. The request was what we had last year. I think from that perspective, assuming we get no new responsibility, then I think we should be okay. Within the next fiscal year, I think the only issue that we've discussed, Todd and I and others who are helping on some of these technology projects, is our estimate when we first did the Capus Fidus plan was about $2.4 million, which is what is available to us, was before they gave us a few new things with the independent expenditure and the Independent Enforcement Council, to the extent that may require anything to be a little bit different. So we're still looking at the work we're doing and the list of business rules. Just to try and figure out, is it still on target? It's not an immediate fiscal year issue, but if we identify that we think either something might be postponed to a second phase because it's not critical, but we'd like it to happen and we need a little bit of money in the out year to design for it, or is it something we really need right away? So we're still looking at some of those issues with the design. So that may change our opinion, but I think right now we think we're on track, and that would be the only issue that we may need a little bit of money. And the question is, for that program, is it this fiscal year or is it next fiscal year? But other than that, I think from a budget point of view, certainly I'm looking for the 30-day amendments, and we're not at that 30-day yet to make sure that there isn't anything different. There are new policy issues in the budget that impact us if they are approved. Certainly public financing would require us to design the Capus Fidus system differently, and that would require money now so that we could incorporate that at least in this fiscal year, to design it correctly, because we couldn't wait there wouldn't be enough time if we waited to phase 2 if that were a responsibility that were included in the budget. So we continue to look at those issues and we raise those. We do have a new deputy secretary. Our deputy secretary has been Alfonso David, and he has been appointed by the governor to be his counsel. And at that appointment, they said was going to be effective April 1st, but in our last conference call that Todd and I had with Alfonso, he let us know that he's already over in the counsel's office, so that he's up to speed by April 1st, and that they introduced our new contact, which is Joe Rubito, And Joe is no stranger to the State Board of Elections because he reminded us that he came here when NVRA first was implemented as a worker for like 6 months, so at least he comes with a perspective of the State Board. He's also the Deputy Director of State Operations, so and Todd and I are meeting with him for our face-to-face meeting tomorrow just to learn what particular ways he has for us to communicate with him differently than the way we have been communicating with Alfonso. But other than that, I think we are continuing to make progress.
Yeah, I think that's exhaustive. Yeah, that's good.
All right, thank you. Kathleen O'Keefe for the council's minute.
The compliance unit in particular is functioning much as it has been. We had our January periodic report that was due on January 15th, and we sent out approximately 2,600 early letters to non-filers who hadn't made that filing. The unit has determined that the top deficiency issue is related to the issue of reimbursements, either related to credit card payments or individual reimbursements. And so we're working diligently to try to help people understand that that does have to be itemized. And we are seeing increased filings where those itemizations are happening. So since the unit is in operation, people are really starting to do that on a significant level. We had a CLE, CPE seminar in Albany during the Election Commissioners Conference, and we've provided 2 webinars on winding down the campaign, and we plan to do more of those. Every 4 years, the board calculates contribution limits. We're going to talk about that in new business because we are at that place again with the adjustment that happens. The board has received requests for the 2015 political calendar. We are awaiting the official filing of the calendar from the legislature. There is some question about the primary that may be moved this year because there's a Jewish holiday that's impacted. We are waiting to hear about that. The legal update that we talked about at the conference has been distributed, so that was signed off by everybody, and we've had some good feedback about that. The independent expenditure regulations, we are in a position where we could start our permanent process. We're looking to go forward with that in the next couple of weeks. That will entail accepting formal comments from the public, so that will give us an idea if we need to do any amendments before they actually become permanent. We have our legislative packet that we've been working on. That will also be discussed in new business. We have been interviewing for the remaining compliance staffers. We do have still some open positions, and that is occurring as we speak. And then finally, we have a motion to dismiss an appeal before the Second Circuit as moot because it was related to the primary election, and that is to be heard by the Second Circuit next week. And that's pretty much it.
All right, thank you. Any questions? Anna Svizzero for election operations.
Thank you, Commissioner. We have been keeping busy between snow days and snow days for county boards, so we've had some interesting conversations. There were some deadlines that were impacted by the weather that we managed to dodge some bullets there, so that issue may come back for conversation at a later date. We have been working on our clear ballot test plans and test cases with NYSTech. We're going to do a little demo here in-house in that this is a central count system, and it really does think outside the box when it comes to something new in the arena of voting equipment. So rather than try to explain it to the staff here, we're going to, Bob Warren is going to set up a demonstration later in the week. If any of you want to see this system, we could certainly, stop in our unit after the meeting, and we'd be happy to run it through for you. We have been continue to revise our procedures, and they're uploaded to the county information portal. We have posted there also the conference presentations, and we have archived a lot of the outdated information and just made it more current and hopefully a little more user-friendly than it was. We have contacted OCA for the list of Supreme Court vacancies. We should have those next week. As Bob Brem mentioned, we published our lever machine replacement report. That was distributed to the governor in both houses in the legislature. We also sent copies to the stakeholders that were mentioned in the legislation. We haven't had any requests for it. I don't know that I would have expected any, but it did go out to those persons to whom we had sent invitations to contribute comments. So it did go out to all of those players. And we'll see what the next steps are in that arena. They have not been shared with us. We are working on the report to the comptroller on county board ballot procurement processes. That is due on Monday, so we're hoping to wrap that up either today or tomorrow. We have been working with the IT department to do the upgrades to the petition aspect of the campaign finance Capus FITUS upgrade that is going on. That's a pretty extensive project, but we meet with them almost weekly, and that continues to make progress. Other than that, we don't have much beyond what's in your board packet on our report. Joe, do you have anything to add?
The response to the controller on the audit with respect to ballot printing. Can
Right.
you tell us what the status is on that?
We drafted, Brian, I took a stab at it, Brian put the finishing touches to it, and we sent that around to all of the senior staff. So we're waiting for feedback. Bob and Todd obviously were out of town last week, so their time to review that was limited. It's a letter, it's not a report, so it really isn't that extensive. It might have an attachment or two of some documents that we have provided to the comptroller in the past, but for some reason can't quite put a fine point on that particular issue. But it's up to, I think, a 3-page letter,
Todd, can you
4-page
tell us
letter.
when we'll get a response on that?
Planning on doing it this afternoon.
Yeah, we got an
And
email.
I don't think the changes are significant that we're looking at.
Yeah.
But as you said,
Yeah, it's a letter, it's not a monster report, and we should be able to get that done. Todd indicated he'd have feedback for the senior staff today at some point, so we can finish that up and get that out on time. I don't see that we can't meet Monday's deadline.
no.
No, I don't either.
Friday would be better in case it snows. It keeps snowing the last 3 Mondays it snowed,
Well, we're
so.
trying to get it done today.
We've had almost every Monday off for the last month.
It hasn't snowed on Friday, but Mondays have been bad around here.
All right. Anything else? Then,
Thank you.
John Conklin,
Thank you,
Public
Commissioner.
Information.
Well, the Public Information Office has been busy with media and other public inquiries. The January periodic filing always brings lots of questions from the media. Also, a lot of people are interested in the 2 new political parties that we have, and there have been a lot of questions about that. We also, Tom made a presentation on the MOVE Act for the winter conference, and we participated in the Q&A sessions at the conference. We were also part of the ECA monthly call at the end of January. Tom and I continue to participate, as everybody else has mentioned, in the Capus FITUS projects and the Nice Voter Refresh project. We've been working on the voter registration form draft with the executive unit, which is in the old business section later in the meeting. As Bob mentioned, Tom and I have been participating in the interview process for Dan Valvo's replacement. There were 51 foils in the month of January. For the website, we posted the lever report that we had to do pursuant to Chapter 273 of 2014. Patrick and Greg for NVRA visited Clinton County for training and a nice voter review since the last board meeting. And that's really it. Do you have anything you want to add, Tom?
Just the only 2 things aside from the IT projects that we are participating in. John and I are also kind of stepping up and working with the IT unit. Just right now, that we have the vacancies, and we'll have another one starting next week. So one of the other big projects that we're looking at is moving our hardware over from the current location in Building 8 over to a new location, which we have a couple of options, I believe. So we're actually going to be having conversations with ITS to try to figure that out so that it doesn't interrupt any of the projects, as well as doesn't interfere with any potential upcoming elections. Aside from that, just from a follow-up from the last meeting, We did provide a signed MOU to the Interstate Voter Crosscheck. We did upload our data file. I am expecting that we would get the results file by the end of this month. We did talk about it at the conference. We did have a couple of counties that did express some interest in participating with our pilot project for evaluating that data. And we'll probably be looking at reaching out to a couple more just to evaluate how whether or not that data really does provide for another opportunity for list maintenance. But other than that, I think that's it.
Step forward. Information technology. Do either Todd or...
Well, I think we've covered a lot of things already with, you know, the three main projects. You know, the Nice Voter update continues with the regular meetings, and we've referred to regular meetings on both the Candidate Information System, CAPIS, and the Financial Disclosure Information, FIDUS, as well as the database move, which we're obligated to do, which kind of relates to that because it's the data, we still have to keep the data we're running and then move it over.
What are the actual next steps in CAPIS FIDUS that the agency is going to take? And is this system going to be developed as a request for proposal, or is it going to be let out to bid, or is it going to be done in-house?
We're looking at doing it in-house, well, in semi-in-house, because we've...
The state.
It's within the state because we have utilized the services of hourly technology information people, HBITS. Hourly based information technology services, HBITS, which are state contract. So they're consultant employees, they're private employees, but it's through a state contract to help us with the project management. We are looking to do the development in-house at this point, just because, you know, it's because of the unique nature of our needs, you know, because we have surveyed in the past, and this, as part of this program, was surveying other avenues for that, you know, including as well as reviewing the city C-Smart, as well as looking at the C-Smart application for, you know, where we have an interrelation at this point. So our schedule, we are, as of today, on schedule. The first step was to analyze the business needs that we have, which is why it entailed regular, and that continues to go on, why it entails regular meetings with because it's CAPIS, candidate, and the financial disclosure. Looking at the needs that we have now to see what the software we have now does, what changes we want to look to the future on both the filer end, which is another aspect that which is another phase we're moving into now, is to get information from the end users before we do the design. But to see what our needs are for the filer side, and as well as for the auditing provision, you know, our side.
That's the critical thing that
Yep.
I'm interested in, is to make sure that we do have a process of end user consultation.
Yep.
And that would be
Definitely in the works.
on both ends, both the treasurers who have to file
Mhm.
and the
The auditors that have to use it.
public group who want to get access to the data.
Yep.
News industry
Consumers
and,
of the data.
right, that's good.
Okay.
And I think one of the items that we.
But that is still on the agenda, that's going to happen.
Oh, yeah.
Yes.
And
Oh, yes.
then,
The only issue that caused it in our, it was a concern, is a concern that we've been working through is, you know, we're modernizing something that's 22 years old. We're upgrading to a new program, the Nice Voter, which is a little bit easier, and we have to move our data center from building 8 somewhere else all at the same time. And we came up with and it's being designed to go into a building that all the answers don't exist because they're getting the new, I forget the acronym for, I call it the nanotech because they keep changing their name, but CNSE, which is Center for Nano.
Scale
Sciences.
Sciences.
Yes. So It's right there by exit 24.
Just let it go over your head.
But-
Asked for the last 7 years, so what?
Just a
But
building.
there have been a lot of times sitting in a room trying to come up with what are our requirements. So we completed that effort to give it to the state information technology people. We just got the response to our list of requirements a couple of days ago. And our staff has been meeting to review what, yes, no, here's a different way to go. And then Todd and I and the staff have a call with them tomorrow, just to go over, it certainly does impact. Is it a pick up and move and we fix later once they've worked out the details? But we did express to them, especially for the statewide database, we don't have a big window to move it. It has to function. It's needed for the federal election, and its end of life is in the middle of next year's federal election. So December, it just has to work. The campaign finance needs to happen as soon as possible. But also, we're really trying to design to a new platform and keep the old stuff running that's 22 years old. So anytime we pick up and move that data center, it's a big concern. It was a big concern when we moved it, when we had to restack a few years ago. So we had, clearly in the project plan is meeting with end users and consumers to get that group involved, in including the counties. We're probably a little bit behind where we wanted to be, but not by a lot, a couple of weeks, maybe a month, just because it's hard for us to sit in another room and figure out the going forward when we have still this basic, what is our requirement, how are we building, and what are the, what do we need to get off the table right away. But from a funding point of view, our estimate was 2.4 million. The state put 1.1 in state information technology, so that's where the workers have mostly been coming from, out of that portion of the money. And what's left is the 1.3 that's in our portion of the budget. That's, from our original estimate, was looking at issues of licensing and equipment. But we won't know that for sure until we know, what design standard are we building to. So it's, that has really been a very critical, important path just to solve. So we had hoped to already have the other part scheduled. Well, it's on the plan, but to have it done. It's probably better that we're a little bit late because it's been hard to travel with all the snow we've had anyway, or come to a webinar. So we're probably about 3 to 4 weeks behind on that one, but we hope we'll get that time back up.
All right, well, I appreciate that report. Risa Sugarman for enforcement.
Good morning, Commissioners. Good afternoon. As Bob mentioned, I don't know whether my auditor was on staff as of the last meeting, but I do have a new auditor, came also from tax and finance, and she is working, has jumped right into the work. I had an attorney who left, went back to the AG's office, but I have hired a new attorney, and he's scheduled to start March 12th, I think, is the paper where he's scheduled to start. We have looked at case management programs, and we've my strategic planner has gone through many of the projects, many of the programs, looked at them, came up with 3, and then she did webinars for those 3, and then we looked at one, and we've settled on one program. So we're going through the process of looking at that, hosting it in the cloud, and doing all that. So that should be hopefully a purchase that we do for the fiscal year, and so we can get it done during this fiscal year. And we're just continuing to do our investigations and moving along.
Has there been any progress in terms of commencing proceedings against the non-filers?
Well, when you mentioned that last time, we did mail out those letters, but the statute that was put into effect last that created my unit does require, and says in 3-1045, that once it comes from the compliance unit, which is 3104A, it must go to the hearing officers first. So I think that the statute included that step of the hearing officers before it goes to the filing of the.
Isn't there a provision that if there are no hearing officers, that it can go directly?
Well, I can proceed by either settlement or filing, but I think that we all talked about trying to get the hearing officers up and running. The numbers that we looked at when we sent out those, we sent out with the, I believe it was the July periodic letters. We sent out 533 letters. Of those 533 letters, we got back, as of close of business yesterday, we received 224 of those letters back as undeliverable, which is about 42%. So that, and then we looked at those approximately 422 letters. About two-thirds of those letters, either candidates or treasurers, already had judgments against them, so that they already had, either those letters had been returned beforehand because they had already moved, and the statute requires that they be sent to the last known address, so that they either had already moved and the letters that were sent before were already sent back. Of those 309 that received the letters, 101 came into compliance, so that was about 33%. And of those 101 who came into compliance, we received 48 telephone calls. We spoke with 48 people. Of those 48 people, 32 came into compliance. So of that, about 67% of the people that we spoke with came into compliance. So we're going to try to look at, a different process to see if we can bring more people into compliance while working with the compliance unit. But I think that doing the hearing officers process will do that. And I think that that's perhaps why the legislature added that part of it into it. We also talked last time about the method of collecting on the judgments, and I sent all of you an email about the process that I'm going to apply to put into place. There is a statute that was passed in 1992. It's called the Statewide Offset Program, and that's a process by which individuals who owe money through state programs during the course of, if a judgment is obtained with due process, that they are notified that their state tax refunds can be taken through notice for those judgments that are brought against them. So we are in the process of working with Budget to become what's called a creditor agency to become part of that process. So that's what that's one of the methods that we're going to attempt to use to collect the judgments. And it's available to us not only for a court judgment, but for administrative settlements and processes as well.
You have to apply for that, you said?
Well, you apply to the Department of Budget to become a creditor agency. And I think that I received an email from Budget yesterday about what they want to know, and I think that they want to know the statutory requirements that allow us that say we can apply penalties, and there are certainly several within the election law that allow the application of penalties. They want to know how many judgments we have pending now, and they want to know an idea of what our judgments and penalties will be in the future. So I think that that's information that we'll be able to provide. And I don't know why, but I think they just want to know if it's not a one-off, a one-time judgment use for this. And they want to know that it's a use of due process. And we certainly do that because we go either to court or when we set up our hearing process, it'll certainly have a due process aspect to it. And then we go to the tax department. They also want to know a due process, and they require a notification to the people who have judgments. And perhaps as part of the welcome letter that compliance sends out, we might want to notify people who are becoming involved in this, that they are, that this is available to them, to us, and that we notify them that they can have their tax refund charged for disobeying any kind of requirements that they file. And then they send out letters and they do the rest of the work with IT, and it's just sort of
It's a great tool.
I'm hoping.
Is there interest on these payments?
Well, it would be whatever our judgment plus interest at the time that it's collected. So we won't lose any of the interest on the judgments. I'm hoping it should be, once it gets into place, it should be just
And Risa, have you followed up on doing any of the collections on the large judgments that were outstanding? I realize you haven't gotten any judgments at all since you've
Correct.
become counsel.
But this would be on pending
Right.
judgments as well, the
Right.
refunds.
Right, but I had been pushing to get counsel's office, your predecessors, to serve information subpoenas and restraining notices on banks and other entities to try to actually collect the judgments on some of the larger ones. Most of them came up with them being frustrated that they were uncollectible. But there were still a couple that were on the list to follow up, and I'm just...
This was my first
inquiring.
step towards collecting the judgments. I have no problem in making that inquiry, but this was my first step.
I still, okay, well, I think that that's something that could be done and that would be useful, and that, especially with staff that's investigatory staff.
I certainly will look into
to
it.
actually collect some of those judgments. Now, your stats with respect to following up, that was all with respect to the July
Yes.
filings? Have any of the letters gone out yet?
No,
The
no,
notices
Commissioner,
for-
because
for
it's my feeling that we should be doing the hearing officer step first. That's what the statute says, and I think that that's...
Well, look, let's pull out what the statute says. The statute gives you the option of continuing the old practice. And I don't, and the problem I'm getting is that we have this long hiatus now where there has been no enforcement at all against the non-filers.
Well, I
I mean, it's your call. I mean, you're independent.
I understand
and
that,
you've
and
decided
that's-
you don't want to do it, you don't have.
Well,
I mean,
it's not that
can't-
I don't want to do enforcement on non-filers. I think that the reason that we have a hearing officer process and is that the legislature felt that it was one step that was necessary, and I think that there is time to give that. We're all working towards getting that process in place, and I think that there is a reason to wait for that process to go into effect. I don't think that there's any reason to, with the numbers of letters that come back and the numbers of people that never get notice that they have these judgments against them, that they have these letters that they're never receiving, I think that there's a reason to try to give them the opportunity to come to know that they have these these processes against them. And I think that the time that it takes to go forward and get the hearing officer process into place is time well spent.
And is that the reason for not sending out the notice letters for the people who haven't filed with respect to the primary or the general election?
Well, I think that when you have the numbers of 224 out of 500 and change letters, that come back, and that a good 60+% of those came back another time, I think there's a good reason not to do that. Those people, 60+% of those have letters that have come back before. I think that there's a reason to believe that people who are sent those letters don't know that the letters were sent because they've either moved or that they're that the address was bad or whatever reason. And unfortunately, or fortunately, the law says the last known address. It doesn't say if the letter comes back with a different address, the letter goes to the new address. The statute says the last known address, so it's sort of, you're stuck with sending a letter to someone who we know it's going to come back, and it's a bad situation.
So what are we doing about it, though?
Well, we're working towards moving forward on the
I don't see how the
hearings.
hearing officer process is going to change.
Well, I don't think that
aspect
the
of it.
notification of the hearing process that will be in the regulations will be the same. I think that we can make a better effort to notify the people who are going through the hearing officer
It
process.
sounds like you've done a thorough job of checking this out. I just might suggest that you try to do something now, only because, very honestly, you are going to be swamped. By the time this catches up, by the time the hearing officer situation is in place and the language for the hearing officer and so forth is set up, I'm going to feel sorry for you, because you're going to go, holy cow, I have this and I have a primary, and all of a sudden it runs away from you, and you're going to have hundreds and hundreds of these things.
But I think that that's right, but I think that those.
You're playing catch up is what I'm saying, instead of I understand the process that you're talking about, and notice, from my point of view, notice is very, very important.
Mm-hmm.
However, as a commissioner here, as part of this organization, I know what happens, and that these things kind of overwhelm you. And I think what the Commissioner Kellner was saying is that if you get a jump on that, do what you have to do now, while the other process is being put in place. If there is another avenue of approach, i.e., the way it was done in the past, you might be somewhat ahead of the tsunami before it hits you.
But if the
Otherwise,
statistics are correct, the tsunami is people who are getting the letters sent, don't know that they're there, and we're getting them back.
It's very different for the periodic report, which is the only report you've sent notices out yet, than the reports for people in the primary and in the general election. The periodic reports basically stay on the filing list forever until they file a termination report. And so you have committees that are 20 years old still on that periodic report. But everybody filed for the primary. Everybody who was a candidate in the September primary or in the November general election. And so those are current lists. And you also have a new statute that was added just a year and a half ago to provide for a $10,000 penalty for anybody who misses 3 filings. And now we've gone 6 filings behind. And I will say that since I've been commissioner, for all the complaining I've done about the problems with the old enforcement unit, they never got this far behind in dealing with the non-filers from elections. And I regard this as a step back, that people who ran in September and November still haven't even gotten the notice letters that are required before we can get the judgments against them.
But there's also the ability of my unit to investigate whether they should be charged with a misdemeanor or not. And that might be
happening?
Well, I don't tell people in public what I do in my investigations.
Well, okay, but I can then publicly criticize that the unit.
I understand,
We
Commissioner.
have,
I understand
we have
what you're
hundreds
saying.
of people who ran in November and in September who have not filed. And not even the notice letters have gone out after the compliance unit has done their effort and tried to get them to voluntarily comply, and we're not getting the judgments. the legislature specifically added this $10,000 fine for those scofflaws who ignore 3 of them. And we haven't even started the process yet.
I understand.
All right. So that being said, separate subject. The old unit used to do an annual report on over-contributions. And I'm just curious on whether either the compliance unit or the enforcement unit is continuing that report. And whether there's, whether the issue of over-contributions is being addressed in a systematic way.
We have actually had a conversation within the compliance unit just about, is that something that's still appropriate for us to do? There would be, my understanding, and obviously I wasn't here the last time this was done, but my understanding was that this is sort of the time of year after you deal with the periodical, that would be done. Or started, anyway. Obviously, with the new compliance unit, we have lots and lots of filings we still haven't worked our way through.
Over-contributions aren't usually, I would have assumed it'd go to the enforcement unit, but I mean, have the two of you discussed this in terms of who's doing this, or are we just going to wait for NYPERG to just attack because it hasn't been done?
Frankly, from my perspective, we have just been doing the huge amount of compliance work that didn't exist at this time last year. I think it might be really fruitful for myself, right, Kim, and Risa to have a conversation about this.
Well, I would strongly urge you to do that. I mean, Risa, do you know what I'm talking about in terms of these old reports? Well, these were the reports that basically led to the referrals that we would give to the district attorneys, which the district attorneys then proceeded to ignore. But
it's the second one. The first one was the failure to file, that at the end of the year we would file.
Right, we gave them both.
The second one was if they, in the process of doing the corporate overcontribution where we had reason to believe that they accepted an overcontribution, that would be referred to the DAs, neither of which were, well, some DAs did something about it.
All right. Well, I guess my overall concern is that there were certainly lots of problems with the old enforcement unit, but there were lots of things that were getting done by the old enforcement unit that I'm concerned have now gone by the wayside with the transition, and that I hate to see us having, a step backwards as opposed to forwards on this. So the overcontribution report was one of those things.
Clearly, I mean, the jurisdiction of the old enforcement unit was much narrower, obviously. And so the overcontribution audits were one thing they could do, and it was done successfully for the most part. And then, obviously, the non-filers was the other thing that the old enforcement unit did. Now and the corporate overcontributions, right? And so, obviously now, we're in a place right now in the calendar where that would happen. So I just think we need to talk about what's the best way to approach that. And Kim isn't here, obviously, today, but I will reach out to her about trying to set up a meeting about that.
Okay. And I'm sure I'll have more to say when we get to the hearing officer process then, especially if the fact that we're not getting any judgments is being held up because we don't have hearing officers. That it's really, all right, we'll get to that. Next is, all right, so we'll move to old business. We'll start with, all right, well, we have 3 resolutions to modify the forms because of the change in the official political parties for 2015. Do either Bob or Todd want to just do a short explanation of what the final text is that's being proposed?
A and B, there's two resolutions that we have before you. Proposed resolution 15-01 is for the change to the voter registration application, and 02 would be to the affidavit oath. But in general, we are amending on the voter registration form section 14, which deals with the political party, or the order that they appear and the names of the parties, that have qualified at the last governor's election. So the new party is Women's Equality, as well as at the time up till Tuesday of this week, it was Stop Common Core, but on Tuesday we received the interim rules of that organization, which has changed their name to Reform Party. So that's part of the change, but also we've been discussing at the meetings here, and we took away from the meetings based on the conversations, the instruction that goes alongside the political party enrollment area to better describe what the statute requires, notice to the public as to the choice they're making. So we've updated the instruction to more align with what the statute says and not necessarily identify any one particular philosophy, and to take that instruction and try and help people to understand what we're talking about. We put a heading above the party section, which would say, I wish to enroll in a political party, and it lists them in order. It has other under there for those people who want to affiliate with another. And then we put a heading, I do not wish to enroll in a political party, and then there's a box for no party. So that's generally the change to the voter registration form. The same issue has to happen on the NVRA, the agency-based registration form. So that's a different number box, 11. And because of the nature of the way the forms are in packets at agencies, the instruction is on the backside of that NVRA form. A similar instruction will have to go to DMV, but they either use our form for that online registration system, but I know in preliminary discussions with them is whatever we finally decide, they'll need time to update that system, and they kind of gave us an indication of what it would take, but we weren't sure whether we'd have the reform or the Stop Common Core at the time. So that is the registration form. The other resolution is simply to make the similar change to the affidavit envelope and get that out to counties. So those are the three forms that you normally approve. We just broke them up into registration versus affidavit for your resolution to consider. So if you...
All right, well, we have the three formal resolutions. We're ready to take a vote on them?
I'd like to move those resolutions.
Those in favor say aye.
Aye.
Opposed? All right, the resolutions are adopted. Is there any need for discussion on the issue of what we're going to tell counties about how we set up the Nysboe system?
Well, I think they're still open. The issue is the other, and I think this is about the best part of whatever's on our agenda to try and figure the others. I know came up at the winter conference, and
so the issue that we need to discuss is what we're going to tell the counties in terms of how to track people who check other.
Correct.
On our system.
I don't think that's the issue. That is, if they check, if they write in one of the identified parties that had run a candidate for governor, then they would maintain that list. That's been the instruction we've sent out in the last 2 times that it's gone around. I think the issue that was raised in January at the meeting that you raised while we were making the presentation was that what to do with those groups that are no longer, that did not run a candidate for governor this time around, that had in the previous election cycle. And there seemed to be some indication that we should continue to track them, although we haven't on a state level been doing that. Now, whether the counties have done that or not, that's entirely up to the counties, but we've placed no obligation on the counties to continue tracking once you've no longer put a candidate on the ballot.
And I think the information, I know Brian is probably better able, is because it's referring to what the the difficulty is you have the statute in the court case, but the court case specifically required us to put other on the ballot, so we have, on the ballot, I said that, on the application. So if individuals, clearly we have to keep track of those that identify with an affiliated group because they put a candidate on the ballot for governor and didn't get 50,000 votes, otherwise they would be a constituted party and we'd have to track them anyway. But the issue we have is, what do we do with all the others that aren't, that because the federal law says federal court case said we had to put other on the form in the first place, we have other. And we've done it a number of different ways, and that's the issue I think that came up. The Commissioner Colliner raised at the
All right, well, let me just frame the constitutional issue, which is that the reason we lost the court case is because of court cases that have said that state burdens on political party organizations have to be reasonable, and that the state should use a balancing test in determining whether or not the state regulation is reasonable as opposed to the burden that they're putting on the right to organize a political party and the equal protection rights that all political party organizations, whether they have the 50,000 votes or not, should be theoretically treated equally, but the courts recognize that if there's a reasonable basis for not treating them equally, that should be balanced in weighing whether or not the state action is appropriate. Now, we lost the court case because the court found that it was not reasonable for New York to take organized political associations off the ballots and off our computer system simply because they lost the 50,000. That was the only issue that was before the court, so the court hasn't gone off on this other issue that I'm raising, which is that at least if somebody has identified themselves as other and there is no significant burden to the state, we are obligated to track that. Otherwise, we're going to get sued on it, and we would lose the lawsuit. So, and I don't see what the downside is to having a category on our computer system that says other. And that if somebody checks other, they go into that category instead of combining the blank and the other. Yes, I know legally, if somebody's other, they're blank. And that those have the same legal consequence, but they do have different consequences for people trying to do political organizing if they look at the list, at the computer list. So I'm suggesting that we need to do that.
Well, I would distinguish that because, you know, the court also recognized that the statute provides that for those who want to become a party, they need to demonstrate initially and continually a sufficient modicum of support, and that's through gaining access to the ballot, and then if you want to maintain your status as a political party, then you have to, that candidate has to gain 50,000 votes, and you have to continue to do that. The difference with that court case was for those candidates that had done one step of the process but not the other, that the state should, at least as long as they continue to provide a candidate on the ballot, meet the first threshold for the modicum of support, that the state has an obligation to continue maintaining the list of their members for that private organization, at least until that time that they no longer meet the modicum of support. So I think that application based on that court case meets the equal protection standard. I don't think we're treating them disparately, and that's the way we have been applying it.
But
that's the way we've been applying it.
But the principle of the court case was that there should be a balancing test of the burden to the state weighed against the effect on the First and 14th Amendment rights of the organizations. And not keeping that other category, there's no justification for the state. There's no burden on the state to create that category. Now, there might be a slight burden on the state if we actually went to the next step and said we should record the actual text entry in the other box that the voter made. And I haven't investigated just what would be involved to do that in our computer systems. But by not tracking the people who have indicated other as opposed to blank, without any burden to us, we are interfering with the organizing rights of those political associations. And I think that it's a lawsuit that we would surely lose if somebody brings it.
The technology-related issue, we kind of solved, as you know, 4 years ago when it took us a lot longer to make these changes because the Nysboe system, when we first designed it, we didn't make an easy way to add parties and change parties. And that's why it took us, I think it took us till summer to get the Green Party added to the system. But the changes at that time now allow, more flexibility to us to deal with this issue. So clearly, because we know the Sapien Party and the Libertarians, we have to keep track of those. There's no question they qualified a candidate for governor on the ballot. And there's a field for other, and then whatever word goes with it. So other plus Sapien, other plus Libertarian would allow us to track those people. We could do either way on all the others. They could put words in there, and we could just lump them all into other, non-Sapient, but it still could all be other appearing on, the website column could say other, and it's when people come to us, we could either identify if a county has given us
Well, let's
Uh,
take
or
last
we could
year
just
as
tell
an
them to do all
example.
the others.
4 years ago, rent is too high, achieved ballot access. They got on the ballot. We maintained their list of others for that 4-year period. It was a small number, but we still maintained that list. This past election, they did not get a candidate on the ballot, as other parties have not in the past too. The Liberal Party, for example. When initially we collected after the Green Party case, they did not get a candidate on the ballot 4 years later. We stopped collecting that information. And that was the policy we put in place when that occurred. We were looking to do, at least my understanding was, we would be looking to apply that same policy we had applied 8 years ago to this point in time until you raised it while we were talking at the conference in January. So I don't understand why we would change an existing policy.
Well, first of all, I'm not sure that I understood that was the policy, because at the time I raised it, in fact, I was told that they were changing the policy the way I wanted to do it, because they would have the issue was whether people who were listed as other Green when the Green Party had been reinstated would get those automatically reinstated without having to re-enroll. And I wasn't even aware that we were tracking others as blanks instead of that separate other category. But now that I'm aware of it, I think that we're legally required to do it because of the theories of the case law cited in that constitutional decision. Do I think this is a major issue? No, and it doesn't affect me, but I just don't understand why we are not tracking that category when it's of no burden to us, and we just invite a potential lawsuit because we're not tracking it. And so that's my concern and why I'm suggesting we change it. But if somebody has to sue, they have to sue. I tried to do my part.
If there's no downside in tracking these, and there is a downside in not tracking these, possibly, what's the decision to make?
Well, it's not a downside or upside. It's a question of application of the statute, as well as an application of what we are authorized to do under the statute in the court proceeding. I don't agree that we're authorized to continue.
Okay, you're not agreeing with him.
I'm not agreeing with him. Yes,
Okay,
it's in short order.
All right, then
Well,
I
we need a
guess-
lawyer.
Todd's a lawyer. Todd's a good lawyer.
No, you're both lawyers, but he's a lawyer too. I'd suggest you let him make the decision.
There you go.
I'm too practical for that, are you kidding me?
I think
All right.
we should table this. and do-
We'll move on.
We still have to figure out what we're telling the counties, though, because
I take it the Republicans are saying no to the change in the policy that I have proposed.
it's mostly a mapping issue.
And they have the right to veto it, so.
Did we pass the,
Yes, we
Forms
did.
are approved.
There could be.
All right.
How long would you keep them?
The other category, you keep them forever. If they've checked the other box, we're simply recording that they checked the other box.
File a new application.
It's
and
like
check
you
it
keep a
box.
Democrat. You
How do
just
you,
keep it.
how do you, well, that's
Or
true.
Republican.
How do you track, or how do you distinguish between tracking specific others as opposed to the other others?
It's more of a mapping issue.
I'm not, yeah.
I mean, from us, and I agree with part of it, is when I first started, and it was a long time ago, 91, but 92 was the first year we canceled everybody for failure to file. Still under the old law, we were sued, and that's part of the NVRA where we could not cancel people just because they failed to vote within a 4-year period. So we had just finished canceling everybody because they had gone through a 4-year cycle of, and we had to go back and find them because we lost the court case and put them back, and that was a pain. So keeping track of people when we set up NVRA was more of a mapping. People when we look at how all the counties do their work, they keep track of all kinds of strange political party names that are not part of any list we've ever given them, but they do. And the way it's all worked,
The local
locals.
counties, okay.
You know, there's 58 there's 62 counties, 58 if you lump New York City all into one. Different organizations, and there's probably 58 ways that they do it because it works for them. And the magic of NVRA is, what do you map to us? So whatever code you use in your county, as long as you map it to us under what we tell you to map it to us, allows us to make the charts and answer questions. So this mapping of others could be handled in many different ways, and the change we made 4 years ago allows us to handle it. We could say to the counties, map it this way, but we got to think 4 years from now, if we're going, we could accommodate whatever words are in that other line, put in the system, and we could deal with it. Because we require, the first code is the category, say like, you know, Democrat, and then it would be blank in the other one. But under other, there's 2 fields. So it's other and then something. And we look for clearly other sapient now, because that got on the ballot, and we would look for other libertarian because that's what was on the ballot. But we still had the old other, rent is too damn high, and whatever else has been in there.
Liberal Party?
Whatever's been in there. Counties keep a lot of
Yes,
stuff.
Liberal Party.
So some of this issue when we go back to counties isn't that you got to look everybody up and map it differently to us. Is many of them already have it, and they have like 32 different categories, and they map 12 of them to us in a specific way. So they map many of those others as blank, because that's what we've told them to in the past. And the only issue is, do they map it to us as other? Now clearly if they don't, I don't think any of us are suggesting that they go back through the big pieces of paper.
No.
If they haven't been tracking this data in the last 8 years, right? But going forward, they would track it correctly. But I don't know from us, the legal entity of other and blank are the same because of this court case. You have no party status. You know, you're not signing petitions. You're not part of the calculation for designating petition. So it's just a matter of, if somebody comes and says, I'd like to know anybody in this group. If we have other and we don't know the group, we can say, here's the 100,000 people that are others. You send them a letter and ask them if they agree with you or not. But at least they have a point of reference to reach out to people and say, instead of me having to go to 11 million people, the federal order said other had to be on the ballot. So you could write in anything that makes you happy, and people do.
I figure that. yeah.
Legal obligation.
And the question is, how do we get it? And we can handle it any number of ways. But I think from us, I think the proposal is instead of others being mapped to blank, we just suggest that others be mapped to other. So we would know the we have to know the Sapiens, we have to know the Libertarians. What's the burden of knowing the rent is too damn high in case they wanted to come back 4 years from now and say, who are my people that they were, I'd like them again? They'll probably sue us because that's what they do, and it takes us an awful lot of time to deal with this that maybe we don't have to deal with. And I think that's the only issue, is how hard is us just tell the counties to map it other. And if
So what you're telling me is it does not put an additional burden on the counties? Because don't forget, if it's coming from here and it's going out to the counties, Buckus County versus XYZ County have totally different setups.
all of their setups allow them to map, so we have to tell them to map to the Women's Equality and the Reform Party are new. We have to tell them Sapient, Libertarian. The only question is, for all the others, do we tell them to map to blank, to other? Meaning I don't know what else is out there, like rent is too damn high, I won't know who they are, I'll just know they're other. Or do we say, tell us whatever the other category is, we can still deal with that? Because all of that, from what we need it for, is simply the chart on the data that we post on April 1st, which is how many others are there. If somebody ever comes to us and says, I'd like the database, we can tell them other. You go figure it out. You go decide you want to write to this group instead of that group.
So I check off other, and I write next to that the Peterson Party.
Mm-hmm.
And you want that tracked?
Well, there's already a field. In other words, we already have to have a field that says other and then libertarian. That's the court case, right? So we have the field already set up. What this would require is, in the situation where it's an other, instead of that second field being blank, it would say other. So it's not like it's even creating the need for an additional field. That field's already required by the court case.
And that's why we could handle it. We could handle it either way. Right now, what we're telling people to do is track it as blank. So in your county, say the Peterson County, the county is right now, whatever they're doing behind the scenes, they're mapping to us as blank. Another county may do them as other something in case they ever have to go find it, because it's easier for them to track it in the computer than to go, 500,000 records and go look for it. So many counties, just because they've had to go back in the dumpster and do this work, I've done it twice, and say, I don't ever want to have to go through the dumpster again. It's easier for the computer to keep track of it. And then if you come along. So other is.
Yeah.
So we're going to direct the counties to track other separately from
I
blank.
should probably check one thing. I have one thing to check, but
Can we come back to this next
yeah,
meeting?
let's put it on to next meeting, and as far as I'm concerned, I think that's where I'm going.
And again, we could either other and deal with all the little pieces, or other.
No, I understand. Yeah, got it. Thank
And
you.
in the meantime, check to find out what's going to happen.
Well, Tom did say that technologically,
Okay,
either of those
on the tech.
options can happen.
All right, good.
Right.
Now let's move on to update on the hearing officer process. And I will say that, especially in view of Ms. Sugarman's comments, I am very disappointed that we're only talking about update.
Well, we have made significant progress here. There was a draft, Brian did a draft, we shared it with our counterparts, they gave some fruitful feedback. We have incorporated that feedback into the draft. There's been a lot of back and forth over the last few weeks. We are hoping, once we have a better idea where the final version is going to end up, because what's happened is some of the drafting of this has raised other issues that were not obvious on its face, and then we need to obviously have a discussion with Risa. I know she has some concerns about a few of the issues that were in the original draft. So we are absolutely making progress on this, and I'm hopeful that by the next meeting we'll have a final product that we could bring to the board.
Well,
That's on the reg.
what about the process of actually engaging hearing officers? Because I'm inclined to say we should adopt emergency regs today so that this issue of hearing officers is not the reason why people who have not filed their campaign finance reports in September or November are not subject to any legal action at all.
Well, the reg is one piece of it. The other piece of it is that we need to have a better idea of what our needs are, or what Risa's needs are. I know that Bob and Todd and Risa have had some discussions about that, and maybe Bob can
But
address it.
Risa's been here 5 months now. What's the story?
Well, I mean, we met with Risa 2 weeks ago, I think it was our last meeting, because Todd and I were out at NASED last week, and we have worked in our many discussions as to the category of what the duties of a hearing officer are. We are ready to submit that for classification purposes. We were told at that time from Dep Secretary Alfonso David that he needed a plan, that Risa, we talked with her. I don't think there's any disagreement between the three of us as to the general concept of it's new, we're not sure how much work they're going to be doing, but they're up to 10 people initially. But we need that plan so that we can move to classify the position so that we can then post it to the website. And that's what I understood Alfonso David was holding up on. So Risa was working on getting us that plan based on our conversation 2 weeks ago.
All right.
But that's to
I want to work
classify, that's
backwards.
to classify the positions.
What
to be
is
able to
the
have them.
timeline now for pursuing the non-filers from the November general election? In other words, people who were required to file reports and never filed any reports for the November general election. What's the timeline? Well, obviously, the first step is we have to have regulations and hearing officers, because Risa said she's not going to pursue these without a hearing officer. So what is the schedule on when we're going to have hearing officers? And then I'm going to turn to Risa and say, what's the schedule on when the notices are going to go out?
Well, she can't know that, though, until
Well, we
she
need
gets her
Risa's
writing.
plan to get the positions classified, because that's what the Dep Secretary said, in order to move, actually post online so that people can say, I'd like to be a hearing officer. And then we have to interview them and recommend to you, here's 10 people
Right.
Let me-
on the
can I-
list. So that's to be a hearing officer, and then in the meantime, it's the regs we've also been working on as to, and sharing and talking as to what those words should be.
These conversations you're having and the difficulty in ironing these resolutions in is because it's a little complicated and you really have to go through this. It's something new that you're doing. Or there's a big disagreement, you disagree, and which is
Well, no, I really don't think we're at a big disagreement, because I think from the three of us, when we've talked,
It's a real problem.
from Todd, myself, and Risa, when we've talked about what it is we're doing, but we have to classify the position, so we've identified a job description, but in our
It's just
conversation.
new and it
Yeah,
takes
right.
time.
That was the essence.
And that's.
So what's the schedule?
Second question is to Risa. You don't seem to be worried about this little
I'm not worried.
hiatus. You're gonna go after these guys.
I am.
At some point and
Yes.
give them hell.
Yes.
That's okay.
What's the schedule for doing that?
I don't have a date that I can tell you, Commissioner. There are a lot of working parts, and I believe we are working expeditiously towards them. I mean, when I have to contact now counsel, Mr. David, because I don't know that I have been switched, and I'll talk to Joe tomorrow, Mr. Rubito tomorrow, to see if I was also switched under his discussion. I haven't been told that yet, so I have to, make that inquiry, and whether I have to discuss. I don't think I have a difficulty in telling Alfonso David that we need 10 because it's a rotating basis. That's what the statute says. We're going to put it into effect, and we'll get back in touch with DOB and civil service to make that happen. Now we have to get 10 attorneys who are going to be willing to take those cases. I already have in my computer the template to make the reports. It's not a difficult thing to make a a failure to file hearing officer's report. The template is there. I know the cases. They'll be done, and then we'll go. I think that we can schedule with certain number of hearing officers 5 or 6 hearings a day. I don't think it's going to be a problem. I think that it's just getting
We have
all
about
the
500
working.
non-filers, so
Well, I think that if out of 300 and some odd notices that went out, we got 100 into compliance, I think a treasurer or a candidate who receives a notice of a hearing is going to come in and say, how can I settle this?
historically, it's roughly about half, right?
It's
More or
difficult to
less.
say with certainty because we've done that notice, so that I was trying to figure out, since we sent out, the compliance failure to file notice last July, I wasn't quite sure what we would see with Risa's numbers, and frankly, Risa's letterhead is a little stronger indication of what's to come than perhaps ours was. So I was just interested in those numbers to see how many people are in the hunt. But it's always been an effective tool, even when we didn't really have the ability to collect the judgment, because the process itself brings people to the table to comply, and that's really what we're all interested in. So I see these numbers today. I mean, there's still 208 people who got the notice that didn't come into compliance, and I don't know how much beating people over
But
the
that's the
head.
July filing,
Right.
and that's the periodic, and a lot of those are just old
Well, that's-
inactive committees.
Well, that's kind of what
Based
we.
on that number that I hear, that's about, several hundred would be the norm for those who we'd end up putting, going forward with the lawsuit and the judgment. And then if some would come into
We
compliance.
used to start
But
the order to show
primary
cause
and
around
the
that
general
number, and-
non-compliance is very different from the periodic non-compliance.
They are different because you're starting with certainly the primary is a smaller number of filers. And they are more active committees because they are actually in a primary, so you're correct on that. The general's a little bit different because it's a slightly larger number, but
And I also think if they start hearing that we're going to take their tax refund, they might come into compliance as well. I mean, I'm really not,
Could
well,
I ask a question? Do they really have to come here for this hearing?
oh yeah.
You can't, what,
Oh, no, they're going to come to Albany for the hearing, and that'll bring them into compliance as well. I have no,
Well, most of them are gonna default.
well, then we'll
The over-
you
start
can't
with
do it
that.
on FaceTime or Skype it or something? I mean, really, people
Why
from-
would I do it on that?
All right,
Well, there's a
Can
set
we-
of requirements.
I am
Follow those rules.
requesting
yeah.
that we have a schedule that shows us the steps that have to be done and the target dates for getting these steps done, and that be presented to the commissioners by the next meeting, with a real schedule on how this is gonna happen.
I hope to have it done by then, too.
Well, that's what I'm
I,
hearing this a lot, and
I-
I'm just very disappointed that this process isn't going forward.
I don't think that's
All right,
a burden. of
I'm
patience.
sorry,
That's
but
all right.
I just think that.
disagree with
I
you.
think that, I'll tell you how I feel. I think that we have made it clear, commissioners have made it clear that we have a concern about this. And we have done some due diligence on requesting X, Y, and Z. The staff and Risa's organization has come through with, I think, legitimate answers to our concerns. And they should have the time to formulate what we need. That's it. Because this could go like that if it gets in place. It'd be your responsibility. Different story. I mean, she's the one on the,
I agree, but
and you're right.
the
bring
fact
it
that
up.
we're still going back on
I
drafts and
understand.
instead of actually getting these steps
I
moved.
think Commissioner Kellner's frustration is the fact that we were at a certain point, everything got turned
remember.
upside down and said, okay, now we got a whole new thing, and then we're at this point.
Well, we
And so
were
it's
at
like-
that point just as I came on. So
That's
this
right.
must
So it's
be my
like,
fault.
You can wear it.
All right, new business, campaign finance contribution limits. We have the resolution and the new numbers.
Yeah.
I don't know that a further explanation is
No, it's not
necessary.
necessary.
Those in favor say aye.
Aye.
Opposed? All right, the resolution's adopted. All right, the 2015 legislative packet. Boy, do I sound like a nudge today.
So I think briefly on the, I don't know who's down here on this one.
Well,
Oh, sorry.
we have a number of items that were in our packet last year that didn't chapter, and they are listed here in the packet that you received. There are a few items.
1 through 12.
1 through 12, exactly. They're actually, yes, 1 through 13.
13.
12 is repeating,
Oh,
13's
I'm
a
sorry,
new one.
I'm sorry. What Bob is referring to is that 1 through 12 are from last year's packet, and they're being repeated again this year.
And we all agree on it.
And we all agree on those. Number 13 is a new piece for this year. It's the tool that would assist with the audit, and we've discussed that, and we all agree about that one. There are 3 items here that we have not reached a complete agreement on. At least on 14 and 15, we are going to continue to discuss those 2 items.
You can probably bring that up on the next meeting.
Yes.
And then the last one, 15-16, the indication is that we are not going to have agreement on that.
That's correct.
Can I ask you why?
Sure.
No,
Thanks for asking.
Thank you for asking. At a board meeting, somebody come up there and I go, you know what, thank you for your input. That was it. We have a tremendous, and I mean tremendous amount of work to do here. And a lot of times people say, well, why don't you do this and this and this? And you're adding to that burden without giving them the necessary personnel, et cetera. And I think that at this juncture, adding more to that cup, which is already runneth over, I think is a mistake. Whether we can certainly revisit this somewhere down the line, but I think it's adding something that is, frankly, at this juncture, not necessary. It's not something that I reject out of hand somewhere down the line, but at this point, I don't think it's
that's your only
appropriate.
objection, the
Yeah.
amount of work that would be imposed on.
It's huge.
Well, it depends on how it's done.
Yes, it depends on how it's done, number one. Number two, we're taking on thousands of,
It's not thousands.
it is. It is.
No,
It's
I
2,000 to
think it's a
3,000
legitimate
additional
concern,
files.
But
It's huge. And for what? And for somebody that's, that's got the bupkis, I'm running for bupkis of the such podunk township, and I have $500, and that's it. And we're gonna take that schmagay, you go there, it doesn't make any sense to me, I don't know. But as I said, that bit, in a perfect world, and under somewhat different circumstances, I say fine, and I don't reject it out of hand, so, to discuss this again in the future, but right now, my vote would be no.
I mean,
in other words, if someone came to you and said, okay, and sat you down, Greg, and said, look, this is the way it's going to be done, it's going to take about this amount of time, we can show you this or that and the other thing, you would soften up.
I never turn a deaf ear to anything, and, I certainly would listen to
I
that.
just wanted, that's why I
No,
asked you.
but at this point, and from my understanding, which may be limited, but my understanding at this point would be.
Well, I
it
think
doesn't
that's
make
what we
sense.
should do, is discuss it further. I think it
And again, I don't-
takes a burden off the counties that we can do much more efficiently.
And by the way, if I see that, then again, I don't have a problem with it. It's
Okay.
nothing
Unfunded mandate.
Yeah, you and I know that very well.
And we can talk about the ballot usability and the canvassing procedures at the next meeting.
and when we share this list, I like to always keep the door open. We had a state of emergency in 13 counties on the day of a village primary, if the village ran a partisan primary. So it once again raised the issue for us that we should touch 3108. When I sent what our proposals were for this year to Todd and Ken and others, I suggested that we've talked about it over time because we have a few hurricanes in the elections, in primaries and generals, that it probably would behoove us to try and see if we can't touch 3108 to deal with this, so that there's more organized than perhaps an executive order at 5 o'clock the night before the election. So I did throw that one out there. We're working on something. I said I'd like to share it once we get it by a little bit. So maybe if we're considering things, we could maybe, hopefully, we'll finish, you'll consider it, and we can come to an agreement on that one too.
Having lived through several of those, yeah, we should fix that.
We really should fix that.
Well, Anna's been drafting a version and sharing it while we've been doing a few other things these last 2 days, so.
The Monroe one, which is withdrawn.
So,
All right, so I'll entertain a motion to approve the legislative list items 1 through 13. Those in favor say aye.
Aye.
Opposed? And then 14 and 15 will lay over.
Put that
You
on
know,
next week, yeah.
also, can we write a very short resolution without putting a date on it that says that we urge as a high priority that the legislature combine the primaries? The
federal
congressional,
primaries, you mean?
no, the congressional and the September primary.
Third rail, huh?
Well,
It's the third rail.
Just ask.
I am just asking.
He's asking another one.
I just think we ought to be on record.
Well, you're saying combine them, not necessarily say when.
I'm definitely not saying when, because I know that there's no way we can agree on that. But to just be on record as an agency saying that we urge the legislature to combine the two primaries, or to change the date of the September primary. How about we put it that way? Now, maybe with the new leadership in the Assembly, there's new chances for some compromise on this, I would hope, and I will renew my efforts in that regard.
Well, just in relation to next, oh, certainly I think it's a wonderful idea. But with regard to, my concern is we finally have some of the components, because the Republican convention for president has been set, the Democrat has been set. Both rules are finalized. Neither of them allow a presidential primary as late as our federal primary set by Judge Sharp, the 4th Tuesday. I think both party rules end the 2nd Tuesday in June, if New York for some reason wanted to be last, who knows. So we are going into next year with the assumption we will have a presidential primary, a federal primary in June, a September primary, and then the November general election. So there will be 4 theoretically if they, and I don't know that we can, I mean, certainly I'm not sitting at the table to say.
So moving the congressional primary either to the presidential primary or the...
Well, 3 is better than 4, 2 are better than 4. But I'm just saying, going into next year, you know, at least, I mean, there was a fear there might be 5 if the Republican convention was substantially different than the Democrat, because they wouldn't line up. So, I mean, those are decisions that they're going to have to make, and probably as soon as this budget's over, they'll ask us for our input. And whatever's left off the table, we'll have to fix in our recommendation to Judge Sharp if they don't fix it. But certainly we're going to be back at this many times this year. So recommending that they solve it, and we're more than willing to talk to them, might not be a bad idea. How they solve it.
I suggest that they give it their best effort to do the right thing. Period.
I just think 2 sentences for us to go on record might be helpful. All right. And then we did draft a resolution on electronic poll books that Commissioner Spano and I support, but again, the Republican response is no go on electronic poll books. Okay. All right, that's everything I wanted to say on that item. And so I think that's the end of our agenda except for executive session.
And next meeting, with various people being away, we were looking, I think, for the first full week of April, so I think that the 7th through the 10th, if what people's calendars look like that week. for the next meeting.
What were those dates? Sorry.
7th is the Tuesday, 8th, 9th, 10th, if we were going to do it.
Any one of those days is fine.
Do either of those days
7th is
matter
good.
to
It's
you?
okay for me.
It's the Tuesday after Easter.
Right. You want to do Tuesday, Wednesday?
I would.
Oh, you know, the,
Slightly later in the week would be better, like
Yeah,
Thursday.
Make it Thursday.
yes,
9th.
I agree.
Thursday's fine. Was that
9th
the
is
9th?
better.
That's fine.
Thursday, April 9th, excuse me? Okay.
All right, so I move that we go into executive session to discuss investigation and enforcement matters.
And
Those in favor?
Aye.
Wait, is there a personnel?
we will or will not come back into a.
We're not coming back.
Okay.
No.
All right, it's unanimously adopted. We will go into executive session.